Hello friends, welcome back to VOWIAS. Welcome to the discussion on Vision IAS Polity PT365 summary. So this is part 3 from Polity, and here we are going to cover the fourth chapter, that is Judiciary. Already we have covered the first 3 chapters. If you haven't watched, I'll leave the link of these videos in the playlist and please do go and watch. So this will be continuation from the previous part, that is part 2, and here we are going to cover the Judiciary topic. Okay, now let's begin. And guys, just a small intimation, the document which we are using for this lecture is the PT365 summary that we have prepared. In this summary actually we have summarized the whole PT365 into less than half of the pages. For example, if Polity PT365 has 50 pages, we have summarized into less than 25 pages, and this summary does not miss any important matter. So you can check the quality of these summaries even in our Telegram channel. The Telegram channel link is also given in the description. You can just watch it. So the best way to prepare this is just keeping the PT365 summary in front of you the PT365 summary in front of you and revising it by listening the lecture at 2x speed or 1.5x speed depending on your convenience. Okay, now let's begin the discussion. The fourth topic, Judiciary. The first one what we have is the contempt of court. The contempt of court was in use from quite some time, and last year we have seen that the Supreme Court lawyer Prashant Bhushan was held guilty for the contempt of court. So this is basically with regard to the comments made by Mr. Prashant Bhushan on social media targeting the Chief Justice of India, the then Chief Justice of India. Okay, so that's why this was in news. So contempt of court, if you see, it is basically an offense of showing disrespect or towards the dignity or towards the dignity or authority of the court. So that is what is known as contempt of court. And the rationale for this provision, if you see, the court must be protected from the attacks so that the authority of the court is not reduced. That is the main thing. So the court should not be defamed, because the image of the court is very much important in the country, so that only when the court has good image, the people will have the trust on the court. Today, if you see in the country, if the people feel that they are being cheated or they are not getting justice anywhere in the country, the last resort to what they will go is court. So that is the reason courts have very high importance in the democracy, and they are sacrosanct. So that's the reason the image of court is very much important. And Article 261, if you see, the full faith and credit shall be given throughout the territory of India to public acts, records and judicial proceedings. So that is the importance given to the judiciary in our constitution as well. And there are this Mulgaonkar principle. So in this Mulgaonkar principle, the Supreme Court has actually showed some restraint in this contempt case. So in 1978 there was this Mulgaonkar versus Unknown case of India, and in this landmark judgment, Supreme Court by 2-1 majority had held Mulgaonkar, who is the then editor of Indian Express, not guilty of contempt, although this is the same bench that has initiated the contempt proceedings. So this counsel of caution is being exercised even in the Prashant Bhushan case. So that's why, remember, the Mulgaonkar principles is related to the contempt case, the contempt of court. Okay, so this data even you can even use in your answer writing as well. Right, so this is what is the Mulgaonkar principle. So actually in the contempt we have 2 types of contempt. One is civil contempt and the second one is criminal contempt. So civil contempt, if you see, in the civil contempt, what is important is that if anyone is showing disobedience or if anyone is not following court order, then it comes under it comes under the civil contempt. But criminal contempt, if you see, if anyone is lowering the authority of court, then this comes under criminal contempt. That means if anyone is passing bad comments on the court, or if anyone is actually defaming court in social media or anywhere, then this comes under criminal contempt. But if someone is not following the court order, then that will come under civil contempt. Okay, so these are the important things that we need to remember from the contempt of court point of view. So the constitutional provisions, if you see the important constitutional provisions, Article 261, it talks about the full faith and credit shall be given to the judicial proceedings. Okay, this is the important article that actually governs the contempt of court cases. And you have Article 19(2), where some reasonable restrictions are placed on the fundamental rights of the people. The fundamental rights, the right to freedom, there are few restrictions that are placed in order to protect the society and protect the country, in fact. Okay, and also protect the rights of other people. And you have Article 129 and 215, where the Supreme Court and High Court are given the powers for the contempt punishment. Okay, so remember these article 129 and 215, under which the Supreme Court and the High Court are given the powers to punish people for contempt of court. And article 142.2 talks about power of Supreme Court to punish for contempt or seek any person's attendance. Okay, so this is the another important article. So remember these important articles, because these days we are seeing Supreme Court is mentioned, sorry, the UPSC is mentioning articles even in the statements as well. Okay. So if you see legal provisions, actually what is contempt of court, what does contempt of court means is not defined in the constitution. This is defined according to the Contempt of Court Act of 1971. So this Contempt of Court Act of 1971 defines the contempt of court, and the contempt of court is basically for disobedience of order. The criminal contempt is for scandalizing court, interference or tend to interfere in judicial proceedings. So for this, 6 months imprisonment or 2000 fine is given, and it cannot initiate contempt proceedings post 1 year of alleged contempt. And so there are few exceptions as well. The exceptions are for the contempt of court: fair and accurate report of judicial proceedings. If anyone is reporting fairly and accurately, then this cannot be treated as a contempt of court. And also, if there is any fair criticism on the merit of the judgment, then even that cannot be treated as contempt. And next one you have is the defamatory attack on judge does not intend to interfere in proceedings. That is also not part of the contempt of court. And also the 2006 amendment introduced truth as a valid defense if done in public interest. That means if someone is talking truth, then in the defense of the public, in the larger public interest, then this also cannot be considered as a contempt of court. Okay. Next one is the next topic is investigation against the Supreme Court judge. So recently, Andhra Pradesh Chief Minister has complained to the Chief Justice of India about the misconduct on part of sitting Supreme Court Judge N.V. Ramana, who is currently our Chief Justice of India. Okay, so before, when he was not Chief Justice, complaint was given by Andhra Pradesh Chief Minister Mr. Jagan Mohan Reddy on N.V. Ramana. So actually, over the years, 3 mechanisms have evolved to investigate cases of misconduct, including cases of sexual harassment, misbehavior or incapacity against the judges. They are in-house procedure, sexual harassment guidelines, and removal for proven misbehavior or incapacity. So these are the mechanisms that has evolved. So from the examination point of view, it is important for us to know about these mechanisms. It is not important for us to know about the politics which is involved in this complaint. Okay, so now we will know all of these important procedures. So if you see the removal of judges according to Article 124.4 of the Constitution, so it is the notice for the removal of judge has to be signed by at least 100 members of Lok Sabha or 50 members of Rajya Sabha on charges of misbehavior or incapacity by the judge. So proved misbehavior or incapacity is one of the major thing on which the judge can be removed. And for this, the presiding officer has to give permission, and if the presiding officer gives permission, then a 3-member committee will be appointed. This 3-member committee, if you see, it consists of Supreme Court judge, the Chief Justice of the High Court, and a distinguished jurist. So this is the 3-member committee, and if the committee finds guilty, then this has to be passed in the parliament by a special majority. Okay. Next one is the in-house procedure of Supreme Court. This in-house procedure of Supreme Court is basically started for the complaints of misconduct, and this can be filed by any person for the misconduct on part of any judge. Okay, and the person to whom the complaint must be filed is either Chief Justice or the President, and the Chief Justice of India is required to determine whether the complaint is either frivolous or serious. If the Chief Justice finds that the complaint involves serious misconduct, then he can seek response from the concerned judge, and also he can appoint a committee for deeper probe. Okay, and the committee will comprise of 3 judges, the judge of Supreme Court and 2 Chief Justice of a High Court. So this 3-member this 3-member committee will decide. And also in 2013, the Supreme Court sexual harassment regulations was brought in. So the sexual harassment regulation, actually a written complaint has to be given by the harassed woman to either the Gender Sensitization and Internal Complaints Committee or the Chief Justice. If the Gender Sensitization in the Internal Complaint Committee is satisfied that the complaint is genuine, then it will constitute a 3-member internal subcommittee to conduct an inquiry, and this committee comprises of the persons nominated by this committee. Okay, and in this committee, a woman should be there, and also outside members also has to be there for the impartiality. So the next news is about Elo Kadar. Elo Kadar, if you see, they were organized in 15 states and leading to disposal of 2.51 lakh cases from June to October. And the Lok Adalat, if you see, it is basically an alternate dispute resolution mechanism where the disputes which are pending in the law pending in front of court and are at pre-litigation stage, they can be settled amicably without any expense on the litigants. So the Lok Adalat merely intends to reduce the burden on the court, and they have statutory status under the Legal Service Authority Act of 1987. It generally consists of a judicial officer as a chairman and a lawyer and a social worker as well. So these three are the main members: a judicial officer, the chairman and a lawyer, okay, and a social worker as well. And the award is deemed to be decree of a civil court, and it is final and binding on all parties. No appeal is made against its award lies before any court. And recently, Chhattisgarh is has become the first state to inaugurate state-level Elo Kadar. So that's why this is important. So which state is the first one to inaugurate state-level Elo Kadar? It is Chhattisgarh. So what are now alternate dispute resolution mechanisms? The dispute resolution mechanisms basically that is non-adversarial, working together cooperatively to reach the best resolution for everyone. Okay, the instruments in reducing burden of litigation on the court while delivering satisfying experience for the parties involved. So this will reduce the burden on the court and also save a lot of time and money even for the people as well. Okay, and the Legal Service Authority Act of 1987 was passed to encourage out-of-court settlements, because these out-of-court settlements, what they will do is they will reduce the burden on the court and also they will save a lot of money for the people as well. And you have the Arbitration Council Act of 1996, which deals with domestic and international arbitration. Next one, the alternate dispute resolution is established on the basis of Article 14, which is equality before law, and Article 21, which is right to life and personal liberty. And you have the DPSP of equal justice and free legal aid, which comes under Article 39A, and this can be achieved by these alternate dispute resolution mechanisms. Okay. So if you see the Arbitration Conciliation Amendment Bill of 2021, so some key amendments are made. So the unconditional stay on enforcement of arbitrary award if arbitration agreement is done by fraud. Either arbitration award was enforceable even if an appeal was filed against it in the court. And it removes the 8th schedule of the Act, which contains provisions for accreditation of arbitrators. So that means the arbitrators definition has been expanded. Because of this, the international arbitration people also, they can come and work here. And according to the 8th schedule, the arbitrator must be an advocate under the Advocates Act of 1961 with 10 years of experience and an officer of the Indian Legal Service among others. Okay, and the benefits, if you see, there are various benefits. First one, it will benefit foreign arbitrators due to removal of qualification, and all stakeholder parties get an opportunity to seek an unconditional stay on enforcement of arbitral award. That is another important thing. Okay, so arbitration is basically the binding award. It's a binding award, and the people come together to find an amicable solution to all parties. Okay, so next one is about the Arbitration Council of India. The Arbitration and Conciliation Act of 2019 establishes for establishment of an independent body of Arbitration Council of India. The Arbitration Council of India will grade arbitral institutions and arbitration of arbitrators. The ACA chairperson, if you see, he has been the judge of a Supreme Court or Chief Justice or judge of a High Court or an eminent person appointed by the Government of India in consultation with the CJI. And it will also have 2 full-time members from amongst the eminent arbitration practitioners and academicians and 1 representative of the recognized body of commerce and industry, and they shall be nominated on rotational basis as part-time member. Okay, so these are the important things that we need to remember regarding the Arbitration Council of India. Okay, so it's a statutory body. Next one is the Singapore Convention on Mediation comes into force. The Singapore Convention on Mediation, it is also known as the UN Convention on International Settlement Agreements resulting from the mediation, and it is the first UN treaty to be named after Singapore. And the convention applies to international settlement agreements resulting from mediation concluded by parties to resolve a commercial dispute, and this will allow the business to seek enforcement of mediated settlement agreement across borders by applying directly to courts. And the convention has 53 signatories including China, US and India. And the significance of the convention, if you see, it will facilitate international trade and commerce by enabling dispute parties to easily enforce their settlement agreements across the borders, because normally the business people will come and invest in another country, and they are the ones who will face major issues because of the legal process in that country. Sorry. and the businesses will benefit from this mediation, and this will also increase the rank in the ease of doing business, because it's an alternate dispute resolution mechanism which is very cost and time saving as well for the companies. And the benefits for India, if you see, it will definitely boost the ease of doing business ranking of India, and it will also provide positive signal to foreign investor about India's adherence to international practice on alternate dispute resolution. Okay, now let's move on to the next one. If you see in the other important news, the first one what we have is the NIBANDU app. So the NIBANDU app is now listed on the Umang app. The Umang app is basically an app launched by the government of India in 2017, basically to bring all major government services on a single mobile app and to make governance accessible to the people directly. And it has about 660 services from 127 departments and 25 states, and about 180 utility bill payment services listed on it. And the Minister of Electronics and Information Technology has put 7 services of Indian Meteorological Department on the Umang app. Okay, so that is the reason Umang app is very much important. Now even the NIBANDU app is also now listed on this Umang app. So because of this, what will happen is that the people who want justice and also the people who take these pro bono cases, they can be connected very easily. Now what is a pro bono case? Pro bono case is basically that work which is, or you can say the work which is done by lawyers at very low cost or at free. Sorry, very low cost or at free. This is known as the pro bono work. And the pro bono legal services, if you see, so they are very much important for the people to get justice, because the lower sections of the people, or the people who are very low income, or people belong to lower strata, they don't have enough money to hire big lawyers and so that they can get some justice. So that's why this pro bono is very much important for the people belong to lower sections of the society. And this will also make sure that the DPSP, which is Article 39A, okay, so under this, which said that the free legal aid and assistance is provided to provide justice to the people, this also can be fulfilled, right? So the next one is the habeas corpus petition. The habeas corpus petition, if you see, the Bombay High Court rejected Arnab Goswami's habeas corpus petition for immediate release. That is the important thing. So habeas corpus is basically part of the Article 32, which talks about the right to constitutional remedies. Because if anyone's personal liberty, or you can say if anyone's fundamental right is breached, then they can directly approach the High Court or the Supreme Court for the breach of their fundamental right. So that's why Arnab Goswami has filed a habeas corpus petition in front of the Bombay High Court under Article 32 for his release, as he said that he was detained illegally, and the petitioner leads the court to determine validity of such detentions, and this can be issued both against the public as well as the private individuals. And the next news is about the plea bargaining. So basically, if anyone is convicted for a criminal offense and has less than 7 years of prison time, then they can bargain there, or you can say they can plead for lesser punishment than what is provided by the law. This is called as the plea bargaining. It was introduced in 2006 as part of the set of amendments to the CRPC, that is the Criminal Procedure Code, and it can be initiated only by the accused. Next one is the right to shebaidship. So Supreme Court has recently upheld the shebaidship right of Travancore royal family in the Padmanabha Swami temple case. What is shebaidship? Shebaidship is basically the right to manage the financial affairs of a deity in the position of a trustee. This is called as shebaidship. Shebaidship means the people who are concerned with that temple, or you can say the people who are involved with the temple from very long time, they will be managing the financial affairs of the deity, on behalf of a trust. The shebaidship is a manager of a property only in title and entitled to custody of both property and idol, and he has no legal claim to the property, which is believed only to rest in the deity. Sorry. Okay, so this is about the right to shebaidship. Next one is the Witness Protection Scheme of 2018. So Supreme Court asked trial courts to consider witness protection scheme against MPs or MLAs under this scheme, and it provides for protection of witnesses based on threat assessment and protection measures, and inter alia include protection, change of identity of witness, their relocation, installation of security devices, etc. And it is approved by the Supreme Court and is binding on all courts of India, because Supreme Court is a court of record, and it provides for State Witness Protection Fund for meeting the scheme expenses. State Witness Protection Fund. And the Malyamat Committee of 2003 also recommended for a strong witness protection mechanism in India. Okay, so these are the important provisions with regard to witness protection scheme. Okay, and guys, that's it for this lecture. And before I leave a small information regarding our initiatives, we have launched Vision PT365 summary, Vision Prelims Test Series summary, Vision Mains Test Series summary, and Vision Monthly Magazine summaries as well. These summaries will help in your revision, which will definitely ensure that you score maximum marks in your upcoming prelims examination, because when you follow these summaries, what will happen is that the time for your revision will reduce, and also you can revise the same document multiple times. Okay, so make the best use of this initiative, and if you have any doubts, you can ask us in the comment box, or even in the Telegram channel as well. The Telegram channel details are there in the description. So that's it guys for this day. I'll see you again with one next lecture. Till then, keep studying and stay tuned. Jai Hind.